I welcome everybody to the Religious Worker webinar. As you see above, the very nice logo, all the religious workers coexisting, and hopefully we'll all be able to coexist with immigration today, and we'll go through the various options that religious workers have in coming to the United States, in immigrating, in coming temporarily, either to work or other religious purposes. And my name is Rosenthal, and I will be hosting the webinar today. Feel free to check out all our other webinars. As you know, these webinars are free. It's a big advantage to everybody just to take care of that, just to use them and take advantage of these free webinars with a lot of good information. Any questions, there will be time for questions at the end, but feel free. You can email me on Rosenthal, CROSENTHAL, my name at Wolfsdorf, WOLFSDORF.com with any questions. Similarly, you can look us up on Facebook and on Twitter. And with that introduction, let's jump into the material. So as you see, there are different religious worker categories. The first two are really two different type of categories. One is the R1 non-immigrant visa, which is for religious workers. The other is what's called the I-360, special immigrant, permanent residence. This is a green card for religious workers. And then, I'm going to spend most of this webinar on those two categories. Those are the most important categories. And then we'll touch a little bit, probably at the beginning, we're going to touch a little bit on the B1 non-immigrant visa, which has many, many applications for religious workers. In addition, those are the main religious worker categories. But in addition, religious workers can qualify for a bunch of other non-immigrant visas. They can virtually qualify for all the other non-immigrant visas that there are. But similarly, you have to meet the requirements, and they're not aimed at religious workers, which tends to mean that you have to aim, you have to adjust your cases in order to meet the requirements that aren't set aside for religious workers. So, for instance, the H-1B, if it's professional physician, the religious worker can sponsor an H-1B. What we normally see is that there's a prevailing wage problem. Nonprofits, especially religious organizations, tend to pay much lower than what's the prevailing wage, which is it's an average wage. It's not the minimum wage. It's not minimum wage of $7 an hour, but it's a minimum average wage for the physician. And again, this is not aimed at religious workers. So what tends to happen is you have to meet the prevailing wage for for-profit organizations. Certain pastors, certain directors of programs, certain religious teachers will meet this H-1B professional criteria, but others won't. But it's always a good thing to check out if possible. Note that there are quotas for the H-1B visas. There are exemptions for nonprofit research organizations, but that's pretty much your only exemption, which typically means that you have to file on April 1st in order to get a quota number, and you have to meet it. You have the start date will only going to be in October the 1st. For those religious workers that tend to be extraordinary, there's the O1 extraordinary ability visa that is applicable to the right type of religious workers. We normally see them in terms of religious Christian artists or religious artists. Some sort of very acclaimed pastor who has lots of press about him, has a lot of authorships, articles about them. H3 is the training visa, and if there's a specific type of training that a person cannot get in their home country, then an H3 training visa would apply to religious training. For those religious organizations, religious universities usually that want students, foreign students, religious students, then they can apply for the F1 visas, J1 exchange visas. It's training similar to the H3, but similar requirements. And then, the L1 visa, the company transfer visas. For instance, if there's a church in one country owned by a church in another country, they can they can transfer what's called their pastors, managers, someone with specialized knowledge. They can transfer them to the U.S. I don't want to spend too much time on the other visas. I want to really focus on the main religious worker visas. But this is just something to keep in mind. Something, when you don't qualify for the B1 or the R1 or the green card, the religious worker green card, then there are other options, or there may be other options, depending on exactly on the circumstances and whether we can fit them into one of these type of categories. Similarly, for immigrant visa options, green card options, there's the PERM labor certification. If you don't meet the religious worker green card, you have to worry about EB2, EB3, backlogs, again, prevailing wages. If someone's works in the national interest, that's also possible for a green card based on their work being in a national interest. Alien of extraordinary ability, similar to the O1, if this particular religious worker is particularly acclaimed, they may qualify under the alien of extraordinary ability EB1 green card category. Okay, so that's with that real introduction, showing the whole picture. Let's go into the nuts and bolts of those categories that typically affect religious workers, more commonly. So the B1 non-immigrant categories is very underused, but there are specific applications for this to religious workers. If you look at the Foreign Affairs Manual published by the Department of Labor, this is listed out in great detail. But these are the common threads on the different applications. There can be no payment from a U.S. source. So if the person is getting paid, it has to be from a foreign church, foreign organization, not from a U.S. source. And then just be very careful whenever we talk about payment, and this will really, permeate throughout the whole discussion of religious worker. In the vast majority of cases, we're referring to what's called non-monetary payments and monetary payments. If you give somebody benefits, any benefits, then that could be considered payment. It will be considered payment if that person's performing services. Typically, in terms of employment, if somebody is not paid, it doesn't mean that they're not employed. The question is, are they performing services, not whether they're paid or not. But in most cases, a volunteer that is working and coming to work every day and providing service every day as an employee, the fact that that the person's not paid is not going to mean that the person's not employed. So the common thread: there's going to be no payment from a U.S. source. There must be an intention to return home. This is a requirement of all of the B1 visas. They have to show ties to their home country. In other words, they have to show that they're not coming here permanently. That they have ties. They have They have ties. They have a home to go to. They have a job to go to. They have assets in their home country. Their family in their home country. And all those factors that I just mentioned, they're factors. The consular officer will usually look at these factors very carefully, weigh them up, the totality of the circumstances, and come up with an adjudication of whether this person really intends to go home, has ties to the home country, or whether they want to stay in the United States forever. And depending, each consulate is different, each country is different. Countries where there are a lot of people that typically flee their countries, it's going to be much harder to establish ties to the home country. Certain countries in Africa, in Asia, other countries that have a very low flee rate, certain European countries, for instance, then it's a much easier standard to manage, to prove. Normally, what happens is you're given status for 6 months. Okay, you can, which means that you really have to look at how long you want this visa for you. If the person's coming for 6 months or less, it's a perfect visa. Extensions can be done, but what you cannot do is you cannot use this as a substitute for work visa. You cannot use it as a substitute to live in the United States. Eventually, what happens is it catches up with you. This visa cannot be used forever. It's normally good for a very short term, 6 months, maybe another 6 months, a year, but nothing more than that. Otherwise, what tends to happen is immigration tends to think that you're using it to work, using it to live in the United States. these are the permissible activities, and they're very specific, and you have to meet them very specifically. So there's three options of permissible activities. Number one is a minister, and this only applies to ministers, on evangelical tours with appointments at more than one church, and will only be supported by collection at meetings. That is one permissible activity on this B1 religious worker visa. Number two, ministers exchanging pulpits. And again, it must be paid by the foreign church, as mentioned above. And again, this one also applies only to ministers. And the third one applies to any members of a denomination, not only ministers. And this is the missionary work B1. It's a very, very popular one. It's something that missionaries can usually readily show. And if the person is coming for religious instruction, aid to the needy, proselytizing, any religious purpose that's consistent with missionary work, then that would be sufficient for them to come to the United States. Again, it's not a work visa. 6 months to a year maximum, you should look at that. Cannot be paid in the United States. Must be paid by a foreign source, and all the other requirements apply to this. They can be reimbursed for expenses. Housing, for instance, would be possible. Again, it has to be religious in nature. Administrative work would not qualify. Another B1 option is what's called B1 in lieu of R1. This is for someone that meets all the requirements for R1, but will not be paid by U.S. source. So typically we call that volunteering, and we'll see all the R1 requirements in a minute. But the B1 in lieu one will be for someone who qualifies for every one of the R1 requirements except for the payment requirement. Payment would be coming from abroad. There's also another B1 a B1 permissible activity listed that is for participants in recognized religious volunteer programs. It's very, very specific what qualifies. I haven't reproduced here. It's complicated and it's very, very specific. If anyone has any questions about this, then let me know, and we can deal with that on a one-to-one basis. Okay, so let's get on to the basic requirements for R1 and I-360 special immigrant religious worker categories. They're very, very, very similar. So most of the requirements I'm going to deal with together, and then at the end I'm going to deal with some issues that relate specifically to R1s and some that relate specifically to special immigrant workers, I-360. So the first requirement is that the religious organization, the petitioner, has to be tax exempt. Number two, it must be a religious organization, the petitioner, or an affiliated organization. An affiliated organization has to be a religious organization and has to be affiliated with the denomination of a religious organization or a religious denomination. The R1 applicant must be the same denomination as that of the petitioning organization. The position petitioning for must be for either as an ordained minister, must be for a religious occupation or a religious vocation, and that includes religious professionals as well. You have to show evidence of intended compensation, how you intend to compensate this person, and you have to show that the beneficiary, the foreign national, is qualified for the position. So let's look at these requirements. Tax-exempt status. You have to have a letter from the IRS identifying that the petitioner is tax-exempt under Section 5013C of the Internal Revenue Code. State exemptions will not be accepted. In the old law, all you had to do was prove that if you would apply, you would be eligible. That is no longer applicable. Really, if you're not even required by tax law to apply for exemption, and most, for instance, most churches don't have to apply to get for 5013C exemption, tax exemption. They don't have to apply, but if they don't apply, that's fine. Obviously, the immigration is not forcing them to apply for something that they're not otherwise would be required to, but they cannot apply for religious worker benefits. And this is one of the fraud, one of the fraud applications. What happened was a few years ago, really now more than 5 or 6 years ago, there was a report that came out. Immigration did a report on religious workers, and they found a substantial amount of fraud in religious work applications. People were, a church or a religious organization would have a member that had lost their work status or for whatever reason needed a visa, and they couldn't qualify for anything else, and it was suddenly a religious worker. And generally the religious worker provisions are quite generous, and because of that, people are taking advantage of it. So around about 2008, they did a whole revamp of the regulations. And one of the things that they did was they made sure that if you're applying for religious worker benefits, the R1 or the I-360, the petitioner must be found exempt by the IRS. If not, then you cannot apply for religious worker visas, and that's it. Okay. Some religious organizations have very old tax-exempt letters. They're still valid. Normally, IRS doesn't update them, but you still have to show some sort of recent evidence that they are still valid. The IRS has a website which publishes all organizations that are tax-exempt, and that's useful evidence. Sometimes the address on the exemption letter doesn't match the petitioner's current address. Sometimes the petitioner moved, or what happened was had an agent filing for that, and that's fine. Immigration will ask for that, though. They will ask for evidence to prove that the petitioner either moved, or they will ask that if the application was filed by an agent has somebody else's name, that this some sort of proof that this was the filing agent. That's again one of the fraud applications, that they want to make sure that that the letter was unfortunately gained. It's not somebody else's letter. So if the petitioner moved, you have to show a change of address, and if for instance, a lease or bought property, some sort of mortgage bill, and if the person that filed was an agent, then you would have to show that the person is an agent, is a lawyer, and with a letter that they filed on behalf of the religious organization. There are group exemptions. These are exemptions that, for instance, the Catholic Church will be exempt, and then every other diocese or every other church that's under that would qualify under the group exemption. For that, you need the denomination's exemption notice, a copy of the 501(c)(3) for the denomination, and number two, you need to prove that this organization, this particular organization, this particular church, this particular religious organization, and its location is currently included in the exemption. For instance, an official church membership directory, or some sort of online list of churches that belong is usually sufficient. Okay. Going on to the next criteria is that the organization, the petitioner has to be a religious organization. We mentioned it has to be exempt from taxation under 501(c)(3). I mean, the assumption is that the exemption has to be done under the church provision of the IRC, of the Internal Revenue Code. If not, it is possible to show that the organization is still religious by other means. That's if the organization qualifies as a religious organization. If it doesn't, if it qualifies under the affiliation, in other words, an organization closely associated with the religious denomination, that they can also qualify if they're exempt from taxation under 501(c)(3). Again, the assumption for this case is that it's not under the religious, the church provision, the religious organization provision, but they also have to show the extra steps. They also have to show that the organization is religious in nature. So any documentation that can show that would be sufficient, normally the articles, the bylaws, etc. Some sort of organizational literature, books, articles, brochures, calendar flyers, internet sites, whatever it may be. Similarly, there's an extra step. They have to show. The denomination has to sign what's called a religious denomination certification or certificate confirming that the religious organization is that the affiliated organization is affiliated with the denomination. The third requirement is religious denomination. And the idea behind this is that the beneficiary would at least have 2 years as a member of the religious denomination for which the organization belongs that is petitioning for that person. The idea is that, today you're Catholic and tomorrow you get a job as a Protestant religious worker is not really tenable. Really, they don't like you to jump from denomination to denomination. So therefore, what they do is they say that you have to be the beneficiary. The foreign national has to be a member of the denomination for at least 2 years prior to filing the application. Religious denomination, it's defined as follows. It used to be a lot more tighter. Now it seems to be a lot more generous. So let's see what it says. So a religious group or community of believers that is governed or administered under a common type of ecclesiastical government includes one of the following: recognized common creed or statement of faith, common form of worship, common formal code of doctrine and discipline, common religious service and ceremonies, common established place of worship or religious congregations, comparable indicia, any other thing. So it's really, as long as there's a common ecclesiastical government, then just about anything else that's similar will qualify. 2 churches, 2 organizations into the same denomination. So it's very, very broad. What about interdenominational churches? So this was addressed specifically in the regulations prior to the change in 2008, and interdenominational churches would qualify. Now, this provision was taken out of the new regulations, and it seems that the common theory is that because the new definition of denomination is so broad that it would include interdenominational churches. As long as you just have to show that the church where the person is currently membered is the same, or has the same ecclesiastical, or it's common type really, not even the same, a common type of ecclesiastical government plus one of those other criteria, that would be sufficient, which is obviously very, 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 very broad. In cases of interdenominational churches, I always like to put extra information, extra evidence to show that these organizations really are similar and, in fact, are virtually the same. So I normally have an examination of creed by an expert. I get an expert to evaluate, the 2 churches. What are their different creeds? Are they the same or are they not? So, I'm a professor at a major university, etc., something like that. It's very, very cogent evidence that their creed is the same. I like to underline or identify their similar practices. For instance, both do baptism, or both have baptism as a fundamental creed, or any other distinguishing practice that both organizations or both churches hold would be sufficient. I would like to highlight that as well. If they belong to a similar or the same, umbrella organizations, many of these interdenominational churches, for instance, have umbrella organizations which they associate with rather than are, formal, that provide formal ecclesiastical government for them. But, membership in a similar organization does show this. Otherwise, we can show that the clergy attend similar conferences, speaking engagements, members in each other's congregations, youth group exchange, gathering, joint missionary programs. I've seen, for instance, a foreign church had a certain pastor come over to their church as a missionary, and then he went back to the United States, formed his own church, and wanted to petition for people from that other church, but they weren't exactly the same, but they had some sort of joint program together where he was a missionary at the other church prior to forming his own church. Qualifying positions. The first one is ministers. This implies that they're ordained. If you're not ordained, you do not qualify for the minister provision, and you have to qualify for one of the others. Religious occupations are not for those that are not necessarily ordained, but do some sort of religious occupation. Religious vocation, similarly, no ordination is required, but some sort of vow, as we'll see in a minute, will be required to show that the person's original is in a religious vocation. In the old regulations, there used to be an extra category for religious professionals. This seems to be taken away in the new regulations. Religious professionals, there's no separate category, but they seem to qualify under the religious occupation. Okay, ministers. So there's certain requirements for ministers, and the minister has, or the foreign national, let's say, has to meet the requirements, the immigration requirements for ministers in order to apply under this category. Very, very often, or maybe not so often, but on a more infrequent basis, someone who qualifies for a minister at a particular denomination or a particular church will not qualify under the immigration laws. So under the immigration laws, the person has to be fully authorized by the religious denomination to perform normal clergy duties. Number two is they have to be trained. They have to be fully trained, complete all the training that the denomination requires. If the denomination has certain standards, they have to meet them. And they must conduct religious worship and other duties of the clergy, and this is really a rational basis test. In the modern era, there are more, I would say, less traditional clergy positions that, usually the clergy would perform, weddings and sermons and all sorts of things that are typically clergy-related. Today, we see clergy that are, have religious technology ministries and all sorts of ministries that are not exactly traditional, and those can qualify, but we do have to show that they do have some sort of rational basis. In other words, they are what clergy do. For instance, the religious technology ministry. If you prove that this person is really a tech guy, then obviously that would not meet the rational basis. If the person had a lot of content management, managed the content of a website, who wrote blogs, for instance, that dealt with religious creed, that would be a much stronger case. Lay preachers are specifically excluded. I apologize, but any pastor, any minister is permitted to perform incidental administrative duties as long as this is not their primary function, it's a religious function. The evidence for a minister: you must have a copy of the certificate of ordination. And number two is you have to prove, as we mentioned before, that the minister is qualified for the position. And this is just more than the ordination, as the slide says, it's more than just the ordination certificate. Immigration will frequently go beyond the ordination certificate, and in addition to proving that it's authentic, they also want to make sure that the person is qualified. Not only that, in other words, that the ordination certificate is not in itself proof of qualification, which you would logically think, but you also have to prove that each underlying qualification is also met. In this regard, the regulations say where there is theological education, where that is required by the denomination, you have to provide transcripts, curriculum, and evidence of accreditation by the denomination. Now, note that this is not this is mandatory. If the denomination requires theological education, they have to provide these documents. And for many non-denominational churches, it can be hard to show evidence of accreditation, for instance, things like that, but it's required. Where there's no theological education required, then you really have to show two things. Number one, you have to show that there are requirements for ordination. There have to be requirements. You can't just say that this person is ordained. We don't have any requirements. You have to establish what the denomination or the organization, the religious organization's requirements for ordinations are. And then you have to make sure that the foreign national, you have to prove that the foreign national has completed all the denomination's requirements. So where there's no theological education required, then it's a two-step process. Number one, you have to show the requirements. Number two, you have to show that the foreign national has met those requirements. Religious occupation. So this is for non-ordained religious workers. So prior to the new regulations, there was a list of some occupations that qualify, but it wasn't an exhaustive list. Number two, some occupations that don't qualify, which seemed to be an exhaustive list, and there was a lot of confusion. And in the new regulations, the list of some qualifying occupations was removed. So there's really no more list of those qualifications that typically qualify. There's now a new definition that says that duties must relate to and clearly involve inculcating or carrying out the creed and beliefs of the denomination. So the important words there are creed and beliefs. Either to qualify for a religious occupation, either the foreign national must be inculcating creed or beliefs, or carrying it out. So those are really, the two options. Primarily administrative positions are specifically excluded, and here we do have a list. Religious janitors, maintenance workers, clerical workers, fundraisers are specifically excluded. Similarly, religious study or training in itself is not considered a religious occupation. And then we have our other options at the beginning. For religious studies, you may want to consider the F1 student visa, the training, the H3 or the J1 non-immigrant options, which are training visas. The third option is religious vocation, and this means a formal lifetime commitment to the denomination. Has to be formal, has to be lifetime. Temporary vows are very, very problematic for these type of visas. So the lifetime commitment, the formal lifetime commitment is established by vows, normally investiture ceremonies, or any other similar formality, but there has to be a formality. So you cannot just say that, well, I've made a vow, therefore it has to be a formal establishment, a formal rite that you go through in order to become part of this religious vocation. Religious vocation refers to a class of individuals recognized by the denomination. So it has to be recognized by the denomination. It has to be a class. So an individual can't say, well, okay, I'm going to vow to donate my whole life and will dedicate my whole life to this particular religious organization, and that qualifies the vocation. It has to be something that is established. Normally, normally it has its own organization in many denominations. The class is its own denominations, or it's listed in the literature, sometimes in the Constitution, the bylaws, or any literature that deals with the denomination, deals with these kind of people. I mean, typically it refers to your nuns and your monks and your certain clerics that have taken vows and have to dedicate their lives to a particular organization. Unlike the religious occupation, once you've established that this person, the foreign national, is a member of the class, either the monk or the nun, then at that point, any duties that this person can do as a member of the class is permitted. In the religious occupation, we have to show that this position is inculcating creed or carrying out creed. But once you qualify for the religious vocation, anything you do is permitted. For instance, a monk could be a janitor, fundraiser, clerical employee. It could be a teacher, math teacher. It could be, anything, as long as that person is part of the class. The next requirement is that proof of compensation must be shown. And again, this is also one of the fraud applications before in the old regulations. you did not have to show how the person would be compensated, and very often they were not compensated, or there were very funky ways of compensating people. So you have to explain how you're going to compensate that person. Monetary compensation, non-monetary compensation, and in very limited cases, self-support is permitted. In the new regulations, monetary compensation and non-monetary compensation are equated. There's no real difference between them. Obviously, the type of proof is different, but non-monetary compensation is considered the same. Okay. So typically, past compensation for similar positions, if you, for instance, you have a religious teacher and you have 10 other religious teachers and they have W-2s, you would submit W-2s, payroll, tax reports, the actual payroll, even pay stubs, proof of medical insurance, and any other benefits that you would give to other employees. If you, in a similar position, you would have to provide for that. In addition, you could budget showing money set aside for this person or for this class of people, verifiable evidence of room and board. If, for instance, the religious organization owns apartments, they could show that they own apartments and that the person is living there or will live there, or teachers live there, etc. If tax W-2s and tax returns are available, they have to be provided for. That's for those in similar positions. The regulations make it clear that they have to be, they have to be submitted. If unavailable, then you can explain. You could clearly give a reasonable explanation for that. For extension applications, you have to show tax documentation, W, tax returns, or any other tax tax document that shows non-monetary compensation for the beneficiary in order to get an extension, and that applies to the beneficiary. You have to show that for the beneficiary, unlike in an initial application where you can show for similar positions, for those with similar positions. We mentioned self-support, and that's very, very limited. You have to meet the very limited criteria listed before. Just to go through it very quickly, you have to establish that the position is part of an established program for temporary uncompensated missionary work. It's part of a broader international program sponsored by the denomination. That's usually the toughest one. The program has to be established, and it has to be for temporary uncompensated missionary work, and that program has to be part of an international program. 2, the program must have had previous R1. So I guess for those that that didn't get in previously, haven't done this previously, it's too late to have such a program. At least those for and at least those that want self-support. What you could do is you could have someone in that program. Well, I guess no, actually it has to be uncompensated. So really, if you haven't gotten onto this one, you're out of luck. The organization must have formal training for missionaries. Participation is an established element of progression in the denomination. In other words, you have to go through this particular program in order to progress in the denomination, and then clearly that the foreign national actually can support his or herself. So it's a very limited situation where self-support will be permitted on an R1 or green card. The final requirement for R1s and I-360 green cards is the beneficiary's qualification. And I call this the unwritten expectation, but this is what you really have to do. And we saw this similarly with the certificate of ordination, proving ordination. Number 1 is this: the petitioner must establish its minimum requirements for the position. In other words, what does the petitioner require as its minimum for this person to come work? Is it a degree? Is it an ordination? Is it 5 years of experience? Is it 1 year of experience? Is it working with children, youth groups? Is it working for people with people at risk? Is it working, is it dealing with outreach? Whatever it might be, you have to establish what that is. And then number 2, you have to establish that the beneficiary meets those qualifications. So other positions, in terms of number 1, the establishing the minimum qualifications, sometimes it's in a constitution, sometimes it's in advertising for a position, sometimes sometimes it's just very well set out in the denomination what it will be, books, especially those very old denominations. And then proof that the person meets the qualification. If it's a degree, then do they have the degree? If it's a degree in theology, is it a degree in theology? If it's experience, 5 years experience in X, do they have 5 years experience? Do we need an experience letter from a previous employer or a previous religious organization showing this work, this experience has been met? Typically what happens is when you get to informal, or I would say very often is, many religious organizations don't have this very well set out, and sometimes this can be issues with immigration, but if the case is generally strong, if the person has very good qualifications, sometimes this can be overcome. But you always want to look at the organizational documents again. Sometimes it appears in the Constitution and the bylaws, and it's a very good source of determining requirements because sometimes they're set out there in these documents. Looking at employees in similar positions is what they actually have is also normally an indication of what those requirements might be. If all the religious teachers have a bachelor's degree in theology, then it's a good sign that this is the requirement. Okay, unwritten requirements, continued. Requests for evidence, as most people know, requests for evidence, RFE, are rampant in the religious worker arena, based on said ad nauseum about what happened with the fraud report and the reaction to that. And one of the reactions is requests for evidence are very, very common. And just some of the things, some of the general threads that you can go through and try address up front will minimize the chance of getting requests for evidence. One of the things that, for instance, that they always ask for is a detailed job description with percentages. In other words, what percentage they are doing counseling, and what percentage they're doing teaching, and what percentage they're doing weddings, for instance. It's not always easy, but do best. You have to come up with some sort of percentage. That's what they're going to be looking for. And typically, they're looking to make sure that that this position is primarily religious. Sample work week is another one that they look for. I know that it's not always exactly the same, but do your best to work out what is the sample work week. What's a typical work week for the person, and the more detail you can put in, the better. What are they doing Monday 9 to 1? What are they doing on Sunday 7 to 10? Or, whatever it is, make a sample work week and include that. Again, they're going to look at the duties. Are the majority of duties religious? Then I like to put in what I call credibility documents. These are documents that establish that the organization is established, and it's established religious organization and it's established organization. One of the things the fraud report addressed was that they did investigations, and they found that these organizations didn't exist. Sometimes they were just houses. Sometimes they just had a sign on the door. Sometimes they were gas stations. Credibility documents are very important. So if it's very important to establish that the religious organization has premises, that it has a lease or a title deed, that either owns the property or it's renting the property. Color copies of pictures are very important. You want to put the sign and the color pictures. One of the things that immigration typically asks for are color copies or pictures or color pictures of the petitioner's location. Utility bills and other proofs of occupation are also very useful. One of the things we used to see quite often is a request for fire occupancy permit. Most of the religious organizations that I've spoken with don't have that. Some do. Again, one of the real idea here is we're painting a picture that this organization is established, that it's real, and that it's a religious organization. It's not that even when you get these requests for evidence, even if they ask for something specific, typically it's not one point, one request that can result in a denial. The officer really will look at the whole application, will look at the totality of circumstances, So they also file occupancy permit. You don't have one, but you have, you have a mortgage statement showing where the church works. Tons of different, utility bills, and signs, pictures, and that won't be fatal in itself. Another thing that immigration typically asks for, a calendar of religious events to show what's going on at the religious organization, flyers or brochures for religious events, financial statements and bank statements to show that that the organization is stable. Membership lists, I have seen asked on a few occasions. Obviously, this relates to privacy concerns with giving a whole bunch of information to even to immigration from from the membership. Usually, if it's possible to to redact some of the information, that would be sufficient. Or if the other documentation establishing a religious organization is very, very strong, then you could leave it out altogether. I've done that in the past, citing privacy concerns, and I haven't had a problem. Publications published or authored by the petitioner, or if the petitioner has books or pamphlets or sermons even are provided, that can establish the organization. Any press, either featuring the petitioner or the beneficiary, even internet press. It doesn't have to be newspapers, so to speak, but anything that it could be even blogs. Even anything that establishes the organization would be helpful as well. For experience, we get letters from former and current employers showing religious experience. If the beneficiary, the foreign national, has publications, that shows that the person's qualifications as well. If they have articles, books, blogs, and they're authored by the applicant, those are obviously very cogent evidence in establishing the credibility as well as the qualifications of the applicant. Similarly, press would be the same thing. Brochures or flyers showing that the applicant did X or Y, sufficient for pastors, for instance. Copies of religious work products, sermons, newsletters, things like that would also help with credibility. Just some particular R1 issues. We see from time to time that I-94 cards are given 3 years on the entry date. Must you correct? Yes, you should correct it. It's clearly a mistake. Now R1s are petition-based, and the person, the foreign national, should only get an I-94 card, only status in the United States, valid until the end of that petition, not a 3 years every time they enter. What if the mistake wasn't corrected? Immigration has said on a few times, both personally, I've heard live as well as written, that their mistakes are not going to affect applicants, but they do want you to correct that, and it's much better to get something corrected rather than to rely on a mistake. Who knows what what immigration will hold? It's certainly not a precedent decision that they will honor their I-94 cards if they've made the mistake. Premium processing. So this is one of the real big deals about the R1 visa, even the I-360s, that they take very, very long. That could take around about six months to apply for an R1 under the regular processing. Similarly, same for I-360, sometimes even longer than that. Premium processing is a service that immigration uses for many other categories, where they will charge an extra $1,225, and they will adjudicate the petition in 15 days, I apologize. And those are 15 calendar days. So there's a very big advantage of filing under this premium processing. It's the difference between 2 weeks and 6 months, possibly even longer. So there's a very, very big advantage to filing under this premium processing. But premium processing doesn't apply to most cases. Most probably because there's a site visit. One of the new regulations is that before an R1 or an I-360 can be approved, there has to be a site visit and an investigation by an immigration officer confirming that there's no fraud in the application. So because this takes so long, the 15 days for premium processing cannot be applied to all cases. They just can't do the site visits in time. So premium processing will only apply in the following situation. If the organization passed a site visit at the petitioning location, then the amount of time, how long ago, it's not clear. It seems I've heard 5 years. It doesn't say that specifically, but it seems that within 5 years, if you had if the organization passed the site visit within 5 years, then that will be sufficient to apply for premium processing. The government memorandum doesn't say that. It just says pass a site visit. So feel free to try premium processing on a case where there's been a site visit more than 5 years ago. If a site visit is not conducted, sometimes we get approvals of R1s and there was never a site visit. Do you qualify for premium processing again? Again, it's not very clear. I've tried it and I wasn't successful. In other words, I had a case with an approval at a certain location, and I applied for without that approval was received without a signed visit. Applied for another case, and they would not honor the premium processing. There are general expedite criteria. For instance, if the U.S. organization suffers severe financial loss, if there's some sort of life or death medical emergency, there are general USCIS immigration criteria that you could meet. Age out, in other words, when an R2, for instance, or a child of an R1 reaches 21, and the green card application is still pending. That's not officially one of the USCIS expert criteria, but in the past, USCIS has treated it as such, and therefore, if a child is going to age out, turn 21, and the green card is not approved yet, immigration will use that as a criteria to expedite. Some R1 peculiarities, some specific R1 rules. Part-time, you can have an R1 for part-time. The minimum is 20 hours a week. For the green card, I-360, this is not permitted. There's a maximum of 5 years permitted in R1 time. It's done in two 2.5-year increments. And any full day that the person was abroad, they can recapture. In other words, what they can do is they can file a new R1 petition and ask to add on any time that during the 5 years that they were abroad for a full day. They can add that back. Non-immigrant intent. Typically, for most non-immigrant temporary visas, you have to have the intention to go home. It doesn't seem that the R1 has this kind of strict intent. You really have to show that the person is just really coming to be an R1 person, to be a religious worker. Typically, if you extend the R1 after an I-360 or after a regular green card, a perm green card has been filed, that will be permissible. I haven't seen any problems with those people having the R1 extensions denied. After adjustment of status, I think it becomes more complicated, and I certainly wouldn't recommend. Well, typically after adjustment of status, the person really needs an advance parole to travel anyway. So if they have once that is filed, it really becomes a moot point anyway. But I suppose if the adjustment of status was sometimes later denied, and that person applied for an R1 visa subsequently, it may be an issue. In practice, it doesn't really seem to be an issue. People that applied R1s after adjustment has been denied don't seem to have that requirement to go home to the home country, and that the R1 is considered. That the filing of adjustment is considered immigrant intent for an R1 renewal. R1s need to be amended if the person, for instance, changes materially their job. That means if they go from part-time to full-time or vice versa, or if the job changes in a material way, that's usually sufficient. If the person just changes location, for an H-1B, that may be a material fact, but for an R1, that's usually not. withdrawals of or terminations of an R1 before the required end of the petition, before the petition expires, have to be done within 14 days of the termination or resignation. I-360 issues for the ministerial category. This is carved in the statute, but the non-ordained categories, in other words, the religious occupation, the professional, which is now part of religious occupation, and the vocation and the religious vocation categories, those are those have a sunset. They've just been extended, so we have a few years to enjoy the religious occupation and vocation categories before they come up for renewal again. They have been renewed many times, so that renewal is expected even when the time comes. Most immigrant visas, you can file the underlying basis, the I-360 or I-140, in concurrent with adjustment of status, the I-485. Religious workers, this is not available. There was the case of Ruiz Diaz, which came out and pretty much said that this was permitted based on the equal protection with other visa categories, but this has subsequently been overturned. So unfortunately, no concurrent filings for I-360 and I-485s. Some more I-360 issues. The major difference between the R1 and I-360 is an experience requirement, that the foreign national must be working in the position for 2 years immediately prior to filing the petition. So if you remember the R1, there was no 2-year experience requirement. The only requirement was that the person be a member for 2 years in the denomination. Here, for the I-360, the person not only has to be a member for 2 years prior to filing in the denomination, but the person also has to be working in the position for which the petitioner is petitioning for 2 years immediately prior to filing the petition. So part of this work experience excludes anyone under, or any experience under the age of 14. If somebody worked under the age of 14, that experience doesn't count. Anything over the age of 14, therefore, does count. Any experience that was gained with unauthorized employment cannot count as well. But immigration does say, the regulations say that the 2 years doesn't have to be exactly the same, doesn't have to correspond precisely, is the language in the regulations to the I-360 position. So, for instance, if a person was a religious teacher and now or let's say a religious scholar and now wants to be a religious teacher, and something like that would seem to be permitted. Must the 2 years experience be full-time? Well, this is interesting. In the before the regulations, the cases said that the experience must be full-time. The statutes and regulations never said anything of the sort. So everyone thought that when the new regulations came out, immigration would have an opportunity, or it did have an opportunity to clarify this. But the opportunity was lost. They did not clarify this. They just mentioned 2 years requirement, and it just seems that the prior cases are still in force, and that the 2 years experience must be full time. What about a break in the 2 years? So if you have a break, in the usual situation, if you have a break in the 2 years experience, then you've lost out. You don't have 2 years of experience in the position prior to filing the application. There's one exception, and you have to meet all of these requirements, all 4 of these requirements. Number one, the beneficiary was still employed as a religious worker. In other words, the employment hadn't been terminated during the break. The break did not exceed 2 years. The break was either for religious training or for a sabbatical that did not involve unauthorized employment. And it's quite a big difference between the two. Religious training is very limited. A sabbatical seems that you could really do anything as long as it didn't involve unauthorized employment. And the fourth is the petitioner remained a member of the petitioning denominations and changed denominations. And one of the applications, it's an interesting application, is what happens if somebody is on an R1 for one organization, wants to change to an R1 for another organization, what happens while the application is pending? Assume that there's no premium processing, the second organization does not have does not passed the site visit, never employed a religious worker before. Then what happens is, so you file a change of employer R1, and it's pending for 6 months. The person can't work for 6 months, and while he's waiting for the application to be approved, what happens if he leaves his current employer during those 6 months? Doesn't work until the very end. Now you've got a break. So the question is, can this be used as a sabbatical? Could the person take a sabbatical? That might be one option. Otherwise, I don't see any other option. You've got a very big break, and it seems unfortunate. For the I-360, like all immigrant petitions or employment-based immigrant petitions, you have to show that the petitioner has the ability to pay the beneficiary. So per regulation, you have to show one of three things. You have to show a tax return, annual report, or financial statement. That's what the regulations require. Obviously, for many religious workers, for instance, they're tax exempt. They don't file tax returns. Some do, but most don't. Annual reports, financial statements, normally for either for big nonprofits but normally very small organizations don't have such organizations. There's an option to pay 100. If there's 100 U.S. employees, you can get a statement from the financial officer, which will be in lieu of the above. But in general, most religious organizations, typically don't have 100 employees. Some do, but most don't. So one way is to show that the person is actually being paid this amount already, maybe in some other capacity, in H-1B status, in F-1 OPT status, some other status. But just in general, USS does seem to be more pragmatic about this requirement for religious organizations. They will look at other things. They'll look at the totality of the circumstances. They'll look at bank statements, whether the religious organization has money, has assets, things like that, pays other people, always on time, with their payments. So, in practice, if the organization is fairly stable, there are other ways to show ability to pay. Just general religious work strategy. Typically what happens is, as we said, you have a membership for 2 years. So if the person that you want to apply for doesn't have membership of the organization for 2 years, you have to wait until that happens. The person has to become a member of the organization, and then for 2 years. Then typically what would happen, they would be on an R1 for 2 years. Why for 2 years? So that they can gain the experience that for the green card. The green card requires 2 years of experience in the position. And then normally the person would file what's called an I-360 after being in the position for 2 years, followed by approval, which would file the adjustment of status I-45. This is a general type of strategy. Sometimes, for instance, if the person worked for 2 employers or worked in the position for 2 years abroad, you could still use that experience for I-360 and file much earlier. Just to end off, I wanted to speak briefly about site visits. As I mentioned before, site visits is something of the new regime, one of the fraud applications. To combat fraud immigration, they call it FDNS, fraud detection. National security agents are sent to each location to discuss or to investigate whether the petition is real, whether there is fraud. Usually what happens is they do come and they come to the site, they will ask questions, they have a list of questions, and make sure that everything is consistent with the petition that was originally filed. Sometimes there are unconventional site visits. For instance, sometimes they'll look on the internet, they will look they'll check out the petition on the internet, they'll check out the beneficiary on the internet. If you have, for instance, the person was applied for as a pastor, and you look on the internet and the person is listed as some sort of missionary or administrative assistant or secretary or something to that effect, we do get these unconventional site visits. Normally what happens is if something's inconsistent, they will report, the investigator will report to immigration. What will happen is they will send the petition back to immigration. Immigration will send a notice to the petitioner saying these were the findings, and normally they have 30 days to combat them, to provide evidence to show that the findings were that were mistaken. Do you have a right to cancel? No, you don't have a right to cancel. Immigration's views that this is an investigation. It's not a adjudicatory process. All they're doing is they're just checking up on you. That's all they're doing. You have the right to refuse them, but that might affect your application. If they can't verify, if they can't verify the information in the petition, then you haven't met your burden with immigration. Even though you don't have to let them in, you don't have to say anything to them. Are they mandatory? Yes, they are mandatory. We have heard of cases where they're not, where they haven't been performed, but the regulations, seem to say that they're mandatory. And according to immigration, they seem to last for 5 years. Many cases are now proved without them. We mentioned before, and the effect that has on premium processing. The real key is to plan ahead, though. This is going to happen. This in all likelihood is going to happen. Make a list of questions that you expect. Make a list of questions that you expect. Questions about the petitioner. What's the denomination? What they do? Where they are? When they have services. All these kind of general questions about the petitioner. Similarly, about the petition, about the make sure the job titles, duties, salaries, qualifications. Everything that is all these questions are going to come up, and it's prudent to plan beforehand. These questions are going to come up, and the plug is really consistency, consistency, consistency. They're looking to match what was in the petition with the investigation. And usually what happens is they'll talk to the person that signs the application. They'll look for that person. But sometimes, they won't. They will, especially if they can't find that person, they'll just speak to anybody about this person. What is this person doing? What are they not doing? What does the organization do? What don't they do? When do they do it? It's very important as well to ensure that key people, especially the front desk receptionists, know about the application and know who to direct the person to. Very often, they'll go to the front desk and they'll say, "Does so-and-so work here?" And the person will never heard of the person. Especially in big organizations, this happens quite often. And when people are working remotely, it's very, very important to do that and to explain, be able to explain to the front desk what may happen, and get the officer, the fraud officer, transferred to the person that can best deal with the questions. That pretty much wraps up the webinar on religious workers. My name is Cliff Rosenthal at the Wolfsdorf Immigration Law Group. Please, if you have any questions, we're going to open it up for questions. Otherwise, it was nice being here today.